Thanks, Delcia. So we're going to jump into the talk here right away. But before we do, I want to touch on a couple of things with respect to SMAP and things that we have going on. So for all the students in the audience here, Delcia would have sent out a survey, I guess last week, Delcia, I believe, that's trying to highlight some of the things that sort of that you've been doing or have been going through in the program. There's a number of things in there to highlight kind of top to bottom, timing, publications, all these different things, attending, things like this. Hopefully that all makes sense and is all quite clear and smooth. You should be able to find it either in the email or on the Teams page. The one thing that I wanted to mention, though, or two things specifically before we jump into this, was one, that when you complete that survey, you will get a link that you can come back and edit it. And our hope is that you can come and edit this over time rather than having to complete this survey over and over. It just lives there. And if something new comes up or you do something new and you want to update that, we have our progress report as of August we have to do. So we'll have to have things updated again in August. So it's nice for you to submit this now as soon as possible and then keep that link and you can come back and update it again in August. And the reason that it's important to submit it right away is we're trying to get a scope of the observership hours that people have, which means working with older adults in a variety of different capacities. And so Delcia just shared the link again, I believe, but it's on the Teams page. You should have email. But essentially, there's a certain number of hours that everyone should have in the program. And I know some people do, some people might not. And so we have some opportunities for people to get those hours, but we need to have a good handle on where people are at. So please go in, complete that survey as soon as you can. We had it set for kind of like by the end of today is kind of the time we're looking for. And if you have any questions on it, please let us know. And then again, make sure you keep that link so that when you come back to update it, you're not having to re-enter information. But we can chat on that if anybody has questions at the end. Otherwise, let's jump into the talk today. So today, I'm pleased to introduce two amazing guest speakers from the McMaster Industry Liaison Office, or Milo. For those of you who might not be familiar with Milo, it's an incredible resource here at McMaster that works with researchers, students, and industry partners, and specifically, looking to translate research, connect with industry, have a startup, a patent, whatever that may be. So they'll be discussing some of these topics today surrounding intellectual property and entrepreneurship. First, Amy Hector. She's a proud McMaster alumni, completing her Bachelor of Science, PhD, and MBA, I believe, here at McMaster. She currently serves as the Business Development Manager of Life Sciences at Milo. And in her role, Amy's responsible for evaluating and managing patent and IP issues, doing marketing and licensing of inventions, supporting funding applications, and creating the creation of startups, primarily within the health science. But she has a lot of expertise that kind of covers a lot of things that we do. And then Glen Crossley, he brings a wealth of information and experience in science and engineering and business. Again, things that are really tied into a lot of the things that we do. He's a graduate of Queen's Engineering Program and currently holds a position of Associate Director of Business Development and Intellectual Property at Milo. So he oversees business development, technology transfers, commercialization here at McMaster and affiliated hospitals, including startups led by faculty and students. And I'm sure they'll talk about all these things, but this just gives you a bit of an overview of some of those things. So we're really excited to have both of you here today, and we're really looking forward to the talk and the discussion after, because there's always a lot of really great questions and discussions after this. So I'll pass it to you now.
Thank you, Dylan. I'll just share my screen here. Looking okay? All right. You can see the screen?
Yeah, looks good.
Okay. All right. Well, hi, everyone, and thank you so much for inviting Glenn and I to join you today for our seminar. We're going to talk a little bit about intellectual property and entrepreneurship today. So just in terms of an agenda for the presentation, I'll first be giving an introduction to Milo. Dylan already did a great job, so I'll maybe go quickly over that slide. and then talk a little bit about intellectual property, including the 4 main types of intellectual property. So patents, copyrights, trademarks, and trade secrets. Then we'll talk about IP and entrepreneurship, and also share some helpful resources that might be useful to you. Okay, so what is the McMaster Industry Liaison Office? Our mission here in the office is really to support faculty and students in building partnerships with industry and the community for research collaborations to help continue to advance your work, as well as to transfer the results of that research to the public for economic and social impact. So the office is composed of a couple of main groups. One focuses on industry-sponsored contracts, so making sure that the contracts are set up to support the collaborations that are happening throughout the university. And we also support a number of grant applications that can help with collaborations with industry and also focus more on commercialization efforts related to research that's happening at McMaster. And then another group at McMaster at Milo focuses more on the intellectual property management and commercialization side of things. And this is kind of where we'll be focusing the discussion for today. So I mentioned intellectual property a couple of times, but what actually is it? So intellectual property by definition is creations of the mind. So it could be inventions, artistic works, designs, and in the legal sense, it provides legal rights to these ideas and inventions. And intellectual property is a very important business asset. So it represents an intangible asset for a company, where a company can get value from this intellectual property by either using it, selling it, licensing it, or even preventing others from being able to copy that work. I mentioned there's 4 main types of intellectual property. So I'll go through them here, and then we'll be diving into them in a little bit more detail in the next few slides. So patents are a way to cover things like processes or compositions, such as a drug or a device, or an improvement on any of these things. Copyright can help protect your written works or recordings, even things like software and pictures. There's trademarks, so you're probably familiar with brand names and phrases or logos. And then there's trade secrets, and these are anything really that's not publicly disclosed, and it's in protection on this is indefinite as long as you keep it a secret, as the name suggests. Okay, so now we'll dive in a little bit more to patents. And I will say, if anybody wants to interrupt throughout the presentation, feel free. I'm happy to answer questions as we go along, or we can wait till the end, whatever everyone prefers. But patents are essentially here to protect ideas and inventions. And in exchange for fully disclosing your invention, you receive a time-limited monopoly on that invention for 20 years. It's not as simple as just filing one patent and then having protection in the whole world. So you actually need to file a patent in each country that you want protection in. And the examination process can be very expensive and can take years. So it's a really important consideration in a business plan to make sure that you're ready to take on this time-consuming and expensive process. It's also important to note that not everything can actually be patented. So there is something called patentable subject matter, which is important to consider if you're thinking about patenting one of your inventions. So for example, you can't patent things like scientific principles or mathematical formulas. And in the US, the definition of patentable subject matter is anything new and useful made by man. But it's also important to note that patentable subject matter can slightly differ between different countries. So it's important to keep that in mind if there's different countries that you're interested in filing a patent application in. And there's 3 main criteria for patenting. So one is novelty. So this means that the invention hasn't been shown somewhere else. So somebody else hasn't come up with the same idea. There's no paper or manuscript or presentation out there that already describes your work. This includes your own disclosures. So if you've presented your work at a conference, or there's an abstract online, or you've published a paper on it, sometimes this can be a challenge for patentability as well. And so one of the first things that we do at Milo when we receive a new invention from a researcher is complete what's called a prior art search. So we actually do a thorough search through PubMed, Google Scholar, patent databases, and online to see if there's any reason why novelty might be a concern for the invention that we're hoping to file a patent application on. Another criteria is it needs to be non-obvious. So this means that there needs to be an inventive step on the technology. So it can't be something that somebody who's knowledgeable in the field would have easily been able to come up with. For example, by maybe combining two things together, it was obvious that what you came up with may have worked. So there needs to be something surprising, or additional work needs to have been done to demonstrate that this wasn't necessarily kind of an obvious invention based on what's already out there. And then it also needs to be useful. And this utility also includes being able to describe the invention in enough detail within the patent application that somebody else would be able to replicate that invention as well. Okay, so I mentioned the patent process can take a while and can be expensive. And this slide is really just trying to kind of highlight the different stages and the costs associated. So oftentimes people will start with what's called a provisional patent application. This application is usually not too expensive. Sometimes it can even be filed within Milo without the use of a patent agent, which helps to save some costs. And I'll talk a little bit more about filing a patent yourself later on in the presentation. But when you start moving towards a PCT filing, which is a more international application, this helps to kind of delay the decision a little bit longer about which countries you want to file in. That can cost, the cost starts to increase there. And then when you start entering each national phase application, this can range from a couple of $1,000s to 10 or even more thousands of dollars, depending if there's translation fees involved. And so that's in each country. Then you need to go through a period of prosecution. So that's in each country, an examiner will look at the application and the claims, do their own assessment of the prior art. And you may have to go back and forth a few times with them to revise the claims and argue for your points. And that's usually in collaboration with a lawyer or a patent agent. And so that can take a few years and also cost a couple of thousand to many thousands of dollars, depending on how much effort is required to get through that process. Then after the patent issues, you need to pay maintenance fees throughout the life of the patent until it expires. So it can take many years and cost lots of money to get patent coverage, even just in a few different countries, for example. Okay, so in terms of what actually goes into a patent application, some parts are kind of similar to what you would see in a manuscript, but other parts are very different. So, for example, you may have the background of the invention, which might include things like the introduction to your manuscript, giving kind of a background to what's already been out there and the need for the invention. Then you get into the details of the invention, so summarizing what it is, providing data to support what the invention is, and making sure that you're disclosing kind of all of the important features and data in the patent that can describe the invention. And this is really important because it helps to support the claims. And the claims are one of the most important parts of the patent application because this is what really determines what rights you have if the patent issues. And typically the claims are set up so that you have a main claim followed by a few, they're called dependent claims or subclaims, which help to further describe the invention and what you're trying to claim. So what I thought would be helpful is to maybe go through a few case examples of patent disputes and how the claims were really important for those cases. And that might kind of help provide or highlight kind of the importance of claims in an application a little bit more. So I'll start doing that in the next few slides. So the first example here is a patent dispute between Peloton and a company called Flywheel. So the situation was basically that in 2018, Peloton actually sued Flywheel, claiming that they were using Peloton's patented leaderboard technology for streaming live classes on their stationary bikes. There were a number of Peloton patents actually involved in this lawsuit. So Peloton had quite a few patents kind of describing this leaderboard technology. And so this is claim one of their patents. We don't have to go through everything here, but essentially what they're claiming is a method to provide these live and archived cycling classes to remote users by using a display screen on a stationary bike to be able for those users to access these classes. This is and more claims. I'm not going to go through them here, but just to kind of show that there's quite a number of different ways that this claim is described. And so in a nutshell, anyway, what Peloton is claiming is that they're having people participate in these live and archived spinning classes with other participants at other locations. And so what ended up happening here with this case was that Flywheel ended up admitting to copying the Peloton technology. They ended up shutting down their live streaming classes. This happened around COVID. They did keep their brick and mortar locations open, but COVID kind of provided some challenges for them there. And Peloton kind of, I guess, took advantage of maybe the opportunity here to offer Flywheel bike owners a free refurbished Peloton bike. So in the process of this lawsuit, Peloton was actually able to gain additional customers because those customers were no longer able to be served by Flywheel, given the patent dispute that had happened. Okay, another example, and I'm actually, oh, Dylan, yes, I see your hand.
Hey, sorry, I didn't really want to interrupt, but I thought it was just something I was curious on, because you mentioned about, inventive step, like it has to be an inventive step or an obvious thing, or like a new piece. Is that what a lot of the sort of lawyering up would entail on something like that? Because to me, that seems, not like a massive innovative thing to have classes and leaderboards. But is that kind of something that gets at that space?
Yeah, so I guess in this case, Peloton was able to have their patents issued around these methods for providing the cycling classes. I've only kind of selected the first claim here and haven't gone deeper into the other claims to get more details on what the, specifics of the mention are. But I guess, Flywheel was basically doing the same thing, and the courts agreed that they were infringing on what was being claimed in the Peloton patent applications. So
yeah, so I guess if the patent exists, it has in theory passed the checks of obvious and inventive and all that, and that's not a decision that has to be made at that time.
Yeah, although I do think there are opportunities to, once a patent is issued, to still have it kind of argued or if there's somebody who thinks that maybe there's an issue with the patent application itself.
Okay.
I haven't actually gone through that or seen that myself, but I think it is possible for that to happen as well. So
Interesting. Okay, thanks. Sorry for interrupting.
no problem. Okay. So yeah, some of you may be familiar with this next example, which is the Apple Watch S9. It's a fairly recent patent dispute that's been going on. It's still ongoing, so it actually hasn't been resolved yet. But basically, the situation is the lawsuit is between Apple and Masimo. So in 2023, just last year, a judge actually ruled that Apple was infringing on Masimo's technology related to blood oxygen sensing. And this was a technology that had been incorporated in Apple's Series 9 and Ultra 2 models. And one of the patents involved is this one that's listed here. So in terms of what Masimo actually claims, I'm not going to read all these words on the slide, but they're basically claiming that they can manage power during continuous patient monitoring by using a lower level of power until a certain threshold is reached, I guess, in the physiological measurements. And then they can tell the device to go to a higher power. And so it's a way to kind of conserve power and battery life. And so they were able to, based on this patent application that they have there and the claims that were issued, they're able to regulate power consumption, changing the number of measurements based on different physiological measurements. I actually am not super expert on how it actually works, but that's the claims that they have for that. So what ended up happening so far anyway is that in October 2023, the US International Trade Commission began to assess whether to ban Apple from importing and selling its watches in the US. In response to this, Apple ended up, to avoid the ban, they actually just paused sales of their Series 9 and Ultra 2 in the US, I think, to kind of figure out what to do next. Just this past January, Apple has decided that they're going to remove the blood oxygen measurement feature. I think they disabled it to avoid an import ban in the US. Obviously, the US would be kind of one of their biggest markets, so it's important for them to kind of continue to be able to sell those devices. And the import ban did go into effect in January 18th. And so the legal battle here is ongoing, but it will probably take a little while to be resolved. But in the meantime, they're still able to sell the devices because they did disable the feature. So I think this is an interesting example of the fact that even some of the most powerful companies, like Apple, for example, are still required to respect the IP rights that are granted on patent applications and deal with consequences if they're caught infringing on technologies. So one interesting option that I think is quite a recent development is that, maybe to get around this issue, Apple could consider licensing the technology or the oximeter technology that Masimo has from Masimo, and provide Masimo with some royalties or whatever they write some revenue for the use of that technology. But my understanding is that at least right now, Apple has no plans to do this. So for right now, there's a ban in place while Apple continues, there's a ban in place, and Apple has disabled the technology while they continue to kind of deal with this legal battle and see if they can appeal it. Okay, so I mentioned we would talk about a little bit about kind of, can you file a patent yourself given how expensive it is? So there's a good example of somebody who did this quite well, and that's Sarah Blakely from She Invented Spanx. So she actually did file her very initial provisional patent application, because I guess at the time, hiring a patent agent to do this for thousands of dollars was not an option. And this patent application that was filed was actually good enough to be the priority document that was used to move forward for the subsequent applications in the different countries that she decided to file in. So I guess the short answer is you can file it yourself. However, if you can hire a patent agent to do it, that's probably wise. And also, at the very least, try and see if you can talk to somebody who's experienced in filing patent applications, because they are quite different than writing a manuscript, for example, and you want to make sure that you're not missing any of the important features. So that's just what the advice that I would say around filing it yourself. Okay, so there are actually different types of patent applications that you can file. One example here is using the NICS sensor. So this sensor here is actually a color sensor that can measure or detect paint and match different paint colors. It was developed here in Hamilton by a McMaster engineering student named Matthew Sheridan. And he filed two different types of patent applications. The first one is actually a design patent, and this doesn't protect the invention in terms of how it works. It actually protects the ornamental design of this NICS sensor. So this is useful if you're working on kind of getting the trademark or the kind of the idea about what the technology is, to protect. So I'm not explaining that very well, but basically it's to protect the design of the technology. So when people are kind of getting used to the sensor and the brand recognition of it in terms of trademark or something like that, this kind of is an early way to protect the design of that idea. But he also filed the utility patent, and that's kind of more what I've been describing with you so far. So he's been able to describe or claim a device that can be used to measure and analyze colors and also interface with smartphones. So I just wanted to explain that there are different types of patent applications that can be filed depending on your business strategy as well. Okay, and another kind of just point about patents is using an example from McMaster as well, or out of the forge at McMaster, which is McMaster's innovator, called ToeFX. So this is actually a healthcare or a health tech company that has been able to sell a product that's useful in treating nail fungus. Don't worry, I haven't put any pictures of nail fungus up on the slide. But this was developed by an alumnus of the forge at McMaster. And basically, they started with one patent application, which was around the composition for treating the nail fungus. But then they've actually been able to broaden their patent portfolio a little bit in the last few years. So now they have a diagnostic for actually diagnosing if a patient actually has nail fungus, and then different methods for treatment. And they actually have now developed a device for visualizing and treating nail fungus. So many companies will not only have, one or two patents, but they may have a variety of patents over time that can help to protect some of their proprietary work. So in summary for patents, it's a multi-step process. It's important for creating assets for a company, and it needs to have a use or an eventual partnership or a license, in order to justify a lot of the time and cost that goes into actually getting a patent application issued and put together. All right, so next we'll move on to copyrights. So copyrights are useful to protect the expression, but not actually the underlying idea itself. So they can be used to protect things like photos or drawings or videos, even sounds and computer programs like software programs. And it allows you to prevent others from copying or making derivatives of this work at least without your permission. Copyright is automatically generated, so you don't actually need to register it, it's free, but you can register it if you want to, and there's some benefits to doing that in terms of making sure that if somebody is actually copying you, it would be a requirement of them to prove that they haven't, and that they created whatever their material is themselves, rather than you having to do that. So there is some benefit to registering it, and usually the registration is not as complex as a patent, for sure. And there's also something that I think is important to keep in mind relating to copyrights, and that's moral rights in Canada. Moral rights. So this is kind of the right to prevent any detrimental or changes to your work. And there's a classic example in Canada of moral rights, and that's kind of in this picture, bottom right-hand side of the screen. So in this picture, this is from the Eaton Centre, and it's a sculpture of a geese that's been done by Michael Snow, and it's hanging in the ceiling at the Eaton Centre. So one Christmas, the Eaton Centre decided that they would tie red bows around the necks of these geese as a nice Christmas decoration, I guess. But the artist wasn't aware that this was going to happen, and he didn't consent to it. So he actually went to court, and he won the case. And so the purpose of moral rights is to make sure that the reputation of the author is author who's not necessarily the owner is being protected, right? So it's important if you're working with copyright to just kind of understand what the moral rights are related to that work. And in terms of length of protection, it's quite much longer than patent applications. So it's the life of the author plus 70 years. And for anonymous work, it's either 75 or 95 years from the date of publication. And in terms of ownership, this can be an interesting topic as well. So often it's the creators that own the copyright. However, there are situations, for example, sometimes employers may own the copyright in work that's created by employees. It depends on the agreements that are in place for the employer. And it can also, if you hire a contractor or a consultant, make sure that there's an agreement in place for that, so you understand who owns the copyright that's being created under the project that's being done. There's a few interesting copyright examples as well. So one is this monkey selfie. So a photographer in Africa, I guess, was setting up to do some wildlife photography, and while he was doing that, a monkey took a selfie and resulted in this cute picture here. And the Wikipedia had the image on its Wikimedia Commons image library. So the photographer was arguing that it was his copyright. The picture was his copyright because he had created the situation that resulted in the monkey taking the picture. But the problem was he didn't take the picture himself. So the courts ended up ruling against the monkey owning the copyright because monkeys as non-human creators cannot create the copyright. And so it's just important, again, as an example, to know kind of who owns the rights to copyright. And then I guess with all of this AI generated work that's going to be more and more prevalent now, it's important to understand, okay, well, what happens with AI generated work and copyright? And I'll just preface this by saying that this is kind of an ongoing legal debate in the field. My goal here is more to provide maybe some things to consider around AI and copyright, but I'm not sure that we have all the answers yet to kind of how to manage this. But in terms of the courts, they're kind of defining original work as something that required a creator's skill or judgment. So it can't just be something that's a mechanical process. And this might be important in the case of AI generated work, because if AI tools are producing new content that's based on, us telling them to do something, there could be a debate about whether that prompt is creating the original work or whether it's something that's just a mechanical process. Some other things to keep in mind is that AI created works may have a risk in violating copyright that's held by others. And they may not receive copyright protection in the same way. So it's just important to think about what are the terms and conditions of the AI software that you're using, because some may end up shifting the liability onto the users, or they may claim copyright for themselves. And so there's, I think discussion around should there be a new set of rules for AI generated work? And I don't have the answers to this, but just some things to keep in mind related to AI if that's something that you're working on. Okay, so trademarks. These are things that, or IP that can help protect things like names and logos, can also be sounds and scents of different services and products. It does require registration, but it's something that can last forever. So usually you need to register. It lasts about 10 or 15 years, and then it needs to be renewed. And trademarks need to be properly policed and maintained. So they cost around $2,000 to $3,000 per country. And on the bottom here, you'll see Peloton, Apple, and Engineers Canada. These are examples of trademarks. Trademarks can get a little bit complicated because you want to make sure that there's not confusion between companies, or confusion that there's some confusion about, if you choose a name and then there's confusion about that in someone else's business. Usually if something's in a different space, it can be okay. An example of that would be Apple computers and Apple Auto Glass. Those are in very different services, and so they each are kind of able to have their own distinct trademarks. And I mentioned it does need to be properly policed and maintained. So Apple is a really good example of a company that definitely polices their trademarks. From what I've read kind of over the last little while, they've policed their trademarks against artists like singers, even school districts, or even food blogs, and they file oppositions that even have already received a logo or a trademark to try and protect their own trademark. So I think in Apple's case, and probably a lot of other companies that do this, their concern is that other trademarks may cause a company either to believe that that company is related to Apple, or it may weaken their trademark. And so they're very proficient at trying to protect their trademarks. And finally, trade secrets. So trade secrets is exactly how it sounds. It's basically keeping something that's important to the business a secret. And you do this by either limiting information between employees, or with confidentiality and employment agreements. They can be unlimited, but there's kind of a risk because you really have to keep it a secret, and it's free as long as you keep it a secret. Or it's free, but it comes with the risk that if it's no longer a secret, you no longer have that kind of competitive advantage anymore. So some famous examples of trade secrets is things like Coca-Cola, WD-40 formula, and the Google search algorithm.
Amy, I think Spencer has a question.
Oh, sorry, Spencer.
Yeah, sorry. So for individuals who are trying to file patents or trying to, have their trademarks or their copyright be protected, it's difficult for individuals to afford an entire team to monitor the state of, the market and the world to ensure that somebody isn't infringing against it. So what mechanisms are in place to deal with that, I guess, difficulty?
Yeah, that's a good question. Yeah,
I
sure.
can take that. So if you're doing something that's part of your research at Mac, the university will take care of patent filings if it's something that it thinks it can extract value from. If you're doing it as an individual entrepreneur outside of like your graduate research, so undergrad stuff and things like that, people do it on their own. Once you get investors, they will often help out. And there's lots of
Right.
cases where there are small companies that will hire, will get a legal firm to take something on a contingency basis, so you don't pay unless they win. We had a group in what was the prior incarnation of the Forge. The little business had a patent around touching a touch screen simultaneously in 2 places, which we all know happens all the time now, but at the time that hadn't really been considered, so it was a really early patent. And they were able to get a law firm to broker a purchase of that patent by a big company. So sometimes, even if you don't have much funding, if you have an asset on the litigation side, you can get someone to engage to support you. But it's also hard to go up against big companies, right? But
Yeah,
there's
so I
lots of
mean,
examples.
it sounds like most of this would come from stakeholders that you have investing in whatever you've come up with, because it would just be difficult for an individual to both come up with something and develop it, as well as monitor the state of the field in terms of whether or not somebody's infringing on their work, like
So,
themselves.
that's a great question. I think yes, on the stakeholders supporting you on when you run into issues, but I think it's important for most entrepreneurs to have a pretty good idea of the patent space that they're working in. Like in the startups I've been involved with, there's always, even on a small team, that's one person's job. They're not doing it full time, but at least once a quarter, they're doing a search and understanding what's being filed by competitors in their space. Apple should have had someone doing that with their oxygen sensor, right?
Yeah. Okay, makes sense.
Yep.
So thanks, Spencer. Okay, so this slide's probably not saying anything groundbreaking, but IP is important for many businesses. So you'll likely have a combination of different types of IP, as Spencer, you've kind of already alluded to. But you might have new ideas or know-how that's either protected by a patent, trade secret. You may have some brand names that could be protected by a trademark, and then you may have copyrights in terms of maybe some software or some designs and some written work. And so kind of looking at your IP portfolio as a whole is an important consideration for all of your business plans. I understand there's some individuals who may not be from McMaster on the call today, so I'll just kind of say that this next slide is focused on the McMaster kind of IP policy, and they can differ between different universities. So just keep that in mind, that you may need to make sure that you understand your own university's IP policy, because it might be different than this one. But at McMaster, in terms of who owns IP, if it was developed by you as a student, so as part of your course requirements or on your own time, and you didn't use a lot of McMaster University resources, then you actually own that IP. If you're a faculty member, a staff, or a graduate student who is being paid to do work at McMaster, then in this case, McMaster owns the IP, and that's where Milo does a lot of work, working on the patents and the copyrights and all that related to McMaster owned IP. And just some other considerations that might be useful just to think about is you want to make sure that you're determining inventorship early when you're working on this intellectual property, and you also want to think about what happens either to the IP or in your business if people leave to do other things, especially as students. You might have a group that's working on this, but a few people might leave to go work in a different company or another job. So kind of how does that look as things evolve? And for software, if you're working on that, just be careful about if you're having contractors and if they're going to be assigning the code to the company, because that could be a concern if they're not. And also make sure you're understanding, if you're using any open source software, what the open source licenses are, because sometimes there's a requirement that if you're using open source, that whatever your derivatives that you're creating are also provided as open source. And that might not be something that you want for your business. Maybe it is, just something to consider. So I just now wanted to share a couple of examples of successful student startups. So the next few slides will do that. This first one here is Muse. So this is a company that was or a product that was created by a company called Interaxon. Interaxon is a startup out of U of T. They were founded in 2007, so a little while ago, but still a good example, I think. They raised over $30 million to get their company up and going. And they have this Muse headband, which is brain sensing headband that's good for sleep and meditation, and I believe a few other things now. But their devices, their sales are still ongoing, and the company is continuing to do quite well. And then this company, Thalamic Labs, they were founded by students at the University of Waterloo in 2012. And this is a wrist EEG device that can allow you to control an electronic device through hand gestures. So they originally sold around 10,000 of these wristbands. They raised quite a bit of money, and then the product didn't really go anywhere, but the patent ended up being assigned to Facebook. So in the meantime, the founders of the company kind of pivoted. They ended up getting or acquiring some of Intel's microchip IP. They rebranded the company, and they tried to compete with Google's Google Glass head-mounted display glasses. They ended up getting, I think, a bricks and mortar location in Toronto at one point, and I think in the end, it didn't really work out or it didn't really progress further, but it's just a great example of how a student startup can raise a lot of money, establish connections with big tech giants, and really kind of do a good job of getting themselves known in terms of the media and getting support for funding and things like that. So these are two examples outside of McMaster. And then thought we could share some examples within McMaster as well. So I'm not sure if anybody knows these two individuals, but the first person, Cameron Siu, he was a McMaster kinesiology student, and his goal was to create a more realistic rowing experience. So he created this Gemini 1 platform, it's called, and ended up completing proof of concept trials with help from the kinesiology and engineering departments here at McMaster. He basically developed a device that attaches onto the bottom of the rowing machine to help provide kind of a tilting aspect to mimic being on a boat. So he did have some early investment, but was then acquired by Water Rower. And I believe there are some of these machines actually here at the Pulse. And then Leanna Genovese, she is she was a McMaster biomedical and mechanical engineering student. She graduated in 2022. And during her academic work, she developed this guided hands assistive technology and developed the company Imaginable Solutions. So she was inspired by a woman who had cerebral palsy and was having trouble painting, which is something that she really liked to do because of her condition. So she created guided hands, and she has done quite well in terms of receiving quite a number of accolades over the last few years for her pitch competitions, the work that she's done with guided hands. She's part of the clinic at MAC, which I'll talk about in a minute. So she's actually a mentor and I think an instructor there based on some of the experiences she's had with Imaginable Solutions. And her devices are being manufactured at the McMaster Manufacturing Research Institute. All right. And just in terms of some resources, you may already be aware of them, but thought might be worth just mentioning them here just in case you weren't. The Forge at McMaster is a startup incubator that is really helpful for students who are embarking on an entrepreneurial journey. They have many different programming throughout the year that can help with learning about different important topics related to entrepreneurship. They have a co-working space. They have a really great network of mentors as well. So the link is kind of written on the bottom of the slide here if you're interested in learning more about the Forge, but they have I think a startup survivor program as well that happens over the summer to kind of give some formal programming and also some time to work on your venture over the course of the summer. There's also the clinic at MAC. So this is more related to anything that's health innovation and commercialization. So they're similar to the Forge in that they do also provide some programming and webinars and different programs to help build your entrepreneurial skills. They also have networking events and have mentorship as well. So it's another great resource for supporting budding entrepreneurs at McMaster. And if you really were excited about all the details that I shared today about patents and copyright and trademarks and trade secrets, then you might be interested in diving into the Fundamentals of IP course, which is available to anybody at McMaster. It was developed by Milo, and it gives you even more information than I shared today about intellectual property, strategies, and also some more practical guides. So you can register for this on Mosaic, and if you Google Fundamentals of IP at McMaster, the instructions will come up on how to do that. So with that being said, that's pretty much all I wanted to talk about today. Thank you so much for your time, and Glenn and I are happy to answer any questions.
Awesome. Thank you so much for going through that, Amy. A lot of really great information and then a lot of really great resources. I think you guys have done an awesome job of kind of building all these resources out for students, because I think they're you know, things that we didn't really talk about when I was going through grad school, and it's nice to get versed in it early. So I'll put it out there. Any questions from the audience for either Amy or Glenn or both of them? As we're kind of waiting, I'm sure there'll be some questions coming in. Is Sydney still here? I don't want to put her on the spot. Oh, she's on hold. She must have to step out. I know I've chatted with Sydney a little bit about some other programs that they have for students to get involved in, you know, taking ideas and things to the next stage. I don't know if you have any like basic, quick info on that as well. Like I know you shared some learning resources, but is that something you can comment on as well?
Yeah, so Sydney was probably talking about the Lab to Market program.
Yes, exactly.
Okay. That program is, I think it's still in the works, so there's not there's no open program to apply for yet,
Okay.
but there will be soon, hopefully.
Okay.
But yeah, so that program provides some funding for students to work on market assessment, to understand to validate kind of the market and the space for their technologies. And it also provides some mentorship and some training as well, alongside some time to actually go out and do primary interviews and do some market research. So yes, that will be a great resource. And I think once there's an application open, we will be, Sydney will be sharing that widely with everybody, because we definitely want lots of McMaster students to apply if they're interested.
Yeah, I think that's great, and like, you know, all the things we have from Forge to you guys to those courses. Seeing any specific questions, it's always a little trickier on the virtual side. But maybe from my side of things, like you mentioned a lot of different types of patents and trademarks and things like that. And I think you touched on it a little bit, but when it comes to like, I think a lot of stuff that students are doing is, you know, they may be developing some specific hardware potentially, but a lot of times it's developing code and processing algorithms and things like that. And I know that that's, you know, sort of sometimes a gray area of if that is patentable or how that kind of fits into all this. So I wonder if you can comment on that a little bit of like how you might go about thinking of that. Like you talked about the open source side of it, but how you might go about, you know, thinking about that as you're writing code or building things out. Do you have any tips or tricks or anything?
Yeah, I can. Yeah,
Go ahead, Amy.
Yeah, I was just going to. Glenn would probably be able to give a much more thorough answer, but just a couple of points to consider from me. One is, you know, a lot of times software and code evolves quite quickly. So the fact that a patent takes quite a few years to actually get issued, by the time your patent is issued, what's actually, you know, in the patent might not even be what you're using anymore for the software. So that's maybe something to consider about whether to patent your software, whether maybe to keep it as a trade secret or go the copyright route. And yeah, I'll pass it over to you, Glenn, to add on
Yeah, I
to
was
that.
gonna say the same thing. I mean, you know, the patents take a little bit of time in software. If you do it, if you patent an algorithm, you can't patent the algorithm itself. You can patent the use of an algorithm to do something, but then it's going to get published. so that anyone can see exactly what algorithm you're using, and if they can iterate or invent around the algorithm you're using and just do a different way of doing the same thing with a different algorithm, you're not protected. So it's sort of a balance. And the other thing on software that Amy touched on is there's one person at Gallings who we know pretty well who spends most of his time or a lot of his time on doing due diligence for investors to make sure that startups haven't incorporated open source code that has language in it that you have to give away what you create. I mean, it sounds like a great way to put pieces of software together. It is, but you have to be very careful to understand the license under which you're using open source stuff, because open source stuff doesn't necessarily mean you can sell whatever you build on it. Sometimes you have to give it away too, which has been a problem for some people that we've dealt with in the past.
Yeah, it makes sense. I mean, it's something that we've always chatted about is like, yeah, the coding software isn't really something you look for in that space, but there could be, as you said, if it's tied to things. And like you said, the timelines. Like the other thing I was going to mention is like Amy, you had the timelines, and I'm actually not sure of like when you get to the patent pending phase, how long that can, or how that, like what is technically patent pending to then where it goes from there.
Yeah, I think once you file a provisional patent application, you're patent pending. And then, yeah, it can take, I would say, 3 to 4 years by the time you file that very initial patent application to getting a patent issued. It does vary, that timeline, a little bit, but that's the timeline I'm looking for.
Yeah, and I mean that's exactly what you were, what both of you are speaking to, right? If it's some code or whatever it may be, if filing something is expensive, takes a long time, and when that's all said and done, it's who knows where things will be, because things change so quickly. Another thing I was going to comment on was like the open source discussion is an interesting one, because as researchers, we're always, I shouldn't say always, but a lot of times we're trying to push towards open source and sharing and collaborating and publishing. And how much does that come up in your world of you know, people that have been working open source, have been doing this stuff, and now realize like, oh shoot, I want to go do something with this, and is there issues in that? I mean, maybe it comes back to the idea that that type of stuff isn't really overly patentable anyways. But any thoughts on that?
Yeah, I mean, it's definitely a balance, right? So we do a fair bit of business in the licensing of quality of life questionnaires, which get published, and the hope is that people will use them, but to make them become the gold standard. But you know, there are things you can do like publish the results, but not necessarily the scoring system, right? For a specific questionnaire. So, you know, in the in the health space, for example, imagine you had a quality of life questionnaire that measured how people feel about the results of an exercise routine that's not specific things that you can measure, like muscle gain or weight loss or something like that. How are they feeling about themselves? Are they doing this and that? Are they able to compete better and stuff like that? If you had a tool like that and you published, you know, the questionnaire, but not necessarily how you're scoring it, or you're providing that only under a license so that people understand that they can use it for academic work. But if a big company is going to want to use it for a trial on a supplement or something like that, they'd have to get a license. So it's a bit of a balance with those kind of things where you want to get it out there, but you also want to retain a piece so that people who are going to use it for profit should be sharing in some way with what you're doing.
Yeah,
I'll make one other comment. Just like, you know, if you look at the sort of like the medical device type companies in the Forge, every one of them is filing patents, right? It's almost like a condition of investment in that space, because in that specific space, your model is generally to get acquired by a company that has the sales force to deploy. You're not going to build a sales force that's going to sell stuff into hospitals. You're going to sell to one of the big players like that. So there are spaces where you actually, it's a non-start. Well, it's a slow starter if you don't have a plan to protect some sort of intellectual property. But then there's stuff in the software space, as you said, that you can do interesting things without having to file patents. And there's the risks of the time frame for software patents. You can accelerate examination of software patents and get it done in a year, sort of a fail fast kind of thing. And some companies will do that on software patents, but as a business sort of decision whether you want to go down that path.
Yeah, I think that makes sense. Okay, any last questions from the field here?
So I'm going to make one more comment then. I always encourage graduate students to do a patent search in the field they're doing research. And it doesn't necessarily mean they want to do anything commercially with their results, but it informs you on what others are doing. And then if you want to get a job at a company that's doing something related to what you did in your graduate work, it's way better to actually be able to reach out to sometimes scientists and other people, technical people who are working in the same area, as saying, hey, I worked on this area in my graduate research. I'm aware that you're doing this kind of stuff. And you can get some of that from journal publications, but you can understand what industry is doing and what industry is protecting. I think that's like, for example, we had a group of engineers, this would have been 7 or 8 years ago, made a handheld skin cancer sensor. So just based on thermistors, it could see skin cancer at a different temperature profile. And I think we were able to find the group at Philips who was working on exactly the same thing, right?
Mm.
And whether they decide to file a patent or not is one issue, but they could reach out to this group at Philips and say, hey, like we just spent 12 months working on this kind of problem. We want a Dyson award, blah, blah, blah. We're looking for work,
Yeah.
and it's useful to sort of have that kind of depth of knowledge of what other people are doing.
Yeah, that's really great advice. I mean, I think it works for grad students, even undergrad students, like a lot of engineering students. And I mean, in the fourth year kinesiology class, we do a lot of this type of stuff. It's, quick getting into things, looking at things, but students often get really interested in it. And to your point, you can find who is doing that. And, you might not be looking to have your own startup, but maybe getting into that. I like that. That's a great tip. Okay, well, I think we'll leave it there. Then if anyone has any more questions, I'm sure they can contact you guys, email or connect with Milo. Like I said, they're a really great resource in all of this stuff. So
I'll just make one more plug for the Lab to Market program. So basically what happened there is there was this Lab to Market program for a few years that was run by a handful of universities, and NSERC occasionally jumped in and co-funded part of it. And then it got paused because NSERC put out a call to do a massive, like, millions and millions of dollars countrywide Lab to Market programs. They're in the midst of calls for proposals on that. So I suspect in the fall or the winter, what we're going to see is a massive effort around delivering this kind of opportunities for students. So you got to imagine it's like doing a co-op placement, but it's on your own idea, right? You're getting bought out of some research for 3 months to do a deep dive on, does your research have commercial potential? So I think everyone should consider that if they're interested. And Dylan, you should consider letting all your students do it if they ask.
yeah, no, I like it. I mean, it's, we do so much in the the literature search and literature review, and to your point of the patent search, I think it's equally as important because sometimes you have literature and you have patent or you have industry market type things, and sometimes the literature is ahead, but sometimes the other side is ahead, and I think it's equally as important. So yeah, we'll definitely be looking at that. And just to clarify with that, the Lab to Market, the idea there is that you're not necessarily developing the technology, you're looking if there is the market to go forward with it, correct?
Talking to dozens and dozens of potential users or people who are, like, if you're you're developing some sort of rehab tool for something or training tool for someone with a disability of one kind or another, you'd be out talking to physiotherapists and physicians and people with that condition and their caregivers and stuff like that to try to understand what you actually need to do to make that a valuable product for them, which can inform how you sort of direct the remainder of your research, as well as give you some ideas about potential commercial potential.
Yeah, that's amazing. And again, ties in a lot to the things that we do here, the user-centered design, and then getting to the market side. One, I guess maybe last comment on that, and I'm losing my train of thought on that. For the lab to market, is there any, does it have to be specifically student driven, or like if they're partnered with another startup or a company that is interested in maybe having another startup, is that something, or is it specifically unique student driven work? I assume it's the latter, but I'm just kind of curious.
Yeah, so that's a good question. We can get you an answer on that. I'd like to think that it's, if there is a partnership there, but the company doesn't necessarily own what the student's doing, which may or may not be the case, then for sure it would be eligible. But we can certainly act and see if there's, these conditions where a company's doing a piece of collaborative research and they would love to have a student do this kind of works to inform them on, the stuff that they actually need to know. So that's a great question. We'll find out.
I think it's probably a gray area, because I've seen my tax applications that are kind of like that almost, where they're doing a background search, or they're not necessarily testing anything just yet. So maybe it becomes into a gray area. But anyways, really exciting stuff. Thanks so much for joining us. I'm sure we'll talk again soon.
Okay, thanks so much.
All right,
Bye.
thanks. See ya.
Okay, bye.
Thank you.